Phoenix, February 2026. The Sullivan family received the denial letter. 3 years earlier, they had given their daughter $40,000 toward a house. Medicaid denied the grandfather's nursing home application. The denial wasn't about the money in his bank account. It was about a Medicaid Asset Protection Trust they never funded. The penalty divisor turned that one gift into $8,000 in monthly nursing home bills. 22 months of denied coverage. And the clock didn't start until the application was filed. The autopsy shows the silent transfer was not the trap. The trap was a second clock most families never learn about until it starts. Across 31 states, the pattern repeats. The council's note, this is not legal advice. Laws vary by state. 3 years before the application, the Sullivan family wanted to help where help was needed. $40,000 to their daughter's first down payment. $60,000 to settle their son's hospital bills after a car accident. $72,000 split between 3 grandchildren's college accounts. Nobody in that kitchen used the word transfer. They were gifts inside a family. 2 years later, the grandfather had a stroke. The rehab discharge planner said he would not return to independent living. His wife filed the Medicaid application for long-term care on a Tuesday in March. The county worker called back 9 days later. She asked for 5 years of bank statements. 3 gift entries appeared inside the 5-year look-back window. $40,000 to the daughter, $60,000 to the son, $72,000 to the grandchildren's accounts. Total transfers across 31 months, $172,000. Arizona's penalty divisor at the time of application was approximately $7,800. Medicaid divided the total transfers by the divisor. $172,000 divided by $7,800 is roughly 22 months. 22 months of mandatory ineligibility. Most families believe the 5-year look-back is the only clock that matters. It is not. The look-back only decides whether a gift gets counted. The penalty divisor decides how many months the applicant goes without coverage. 2 different clocks. 2 different consequences. The mechanic is simple once it is named. During application review, the state sums every uncompensated transfer in the prior 60 months. That total is then divided by the state's published average monthly cost of nursing home care. In recent years, those divisors have ranged from approximately $6,000 to over $14,000. The exact number depends on the state. The math returns a number of months. That number is the penalty period. The applicant is otherwise eligible, but Medicaid pays nothing for those months. The nursing home bills land on the family. The cases we examine share 3 repeating patterns. Pattern 1. The silent gift. Helping with a down payment, paying off a medical bill, funding a wedding. These never feel like transfers to the families who make them. Medicaid counts them the same as a wire to an offshore account. Pattern 2. The joint account that became a one-way bridge. Adding an adult child to checking or savings looks like estate planning. When the child withdraws funds for their own use, the withdrawal counts as a transfer from the parent. Pattern 3. The unrecorded house transfer. Adding a child's name to a deed without consideration is treated as a partial gift. The gift amount equals the value transferred. The county recorder timestamps it, and the divisor does the rest. The penalty divisor is not the same number in every state. The published averages we reviewed ranged widely. Roughly 6,500 in some southern states, over 14,000 in the Northeast. A lower divisor means a longer penalty for the same gift. The county worker reviewing the application does not negotiate the divisor. It is set by state rule and applied mechanically. Most families learn the divisor for the first time when the denial letter arrives. By then, the parent is already in the facility. The penalty period has not yet started running. Because the clock does not start at the gift, it starts at the application. We track the divisor by state in the pre-autopsy checklist. Link in the description, haircouncil.com/checklist. Before we close this file, one more thing the case revealed. The Sullivan family had reviewed their estate plan 4 months before the gift. The plan did not mention the divisor. Before the 3 deliberate choices, one term deserves its own definition. A Medicaid Asset Protection Trust is an irrevocable trust funded at least 5 years before nursing home application. The grantor keeps income from the trust assets. The trust keeps the principal, protected from Medicaid recovery. The Sullivans never funded one. The Carters did not either. Their attorney structured documented loans instead, because Carter wealth was inside the 5-year window. Both strategies work. Both require deciding before the clock starts. The cases that survive the divisor share 3 deliberate choices. First, any gift inside 5 years of expected care is documented as a compensated transfer. Otherwise, it must stay inside a Medicaid Asset Protection Trust. The trust has its own timing rules, but it stops the lookback from counting later. Second, joint accounts get unwound or converted to in trust for structures that do not appear as transfers. Third, deed changes are timestamped through formal title insurance review. Consideration and ownership get recorded in the same instrument. The autopsy shows that families who consulted a Medicaid attorney before the gift kept the divisor at 0. Most who consulted after the stroke did not. Compare the Carter family in Pennsylvania. Same year, same family wealth. The Carters had given each of their 3 adult children $25,000 toward graduate school. The difference was in the 4 months before the checks. They consulted an elder law attorney. The attorney structured each transfer as a documented loan, a written promissory note, a repayment schedule, a market interest rate. 3 years later, the father needed long-term care. The county worker reviewed the same 5 years of bank statements. She counted the loans as countable assets, not gifts. The penalty period was 0. The autopsy shows the same gifts, but 2 different timestamps, 2 different countdowns. The penalty divisor is not negotiable inside the application. Appeals exist. They are narrow. The grounds are clerical error, hardship under state-specific definitions, or proof the transfer was for fair consideration. Most appeals we reviewed in recent years turned on documentation the family did not keep. No receipts, no purpose statement, no witness. Next on the council's review desk, the family that won the appeal but lost the house anyway. The file closes here. Yours doesn't have to open the same way. New case every week.